Ms. Monthei, we're ready for your argument.
May it please the Court, Counsel. Your Honors, Annett Holdings comes before the Court today requesting the Court to rein in the lower courts in their current practice of applying a standard of proof by plaintiffs seeking class action certification that's lesser than what our rules intended. Both the District Court and the Court of Appeals essentially, in this case, applied such a loosened standard of proof by the plaintiff that it really wasn't a standard at all. We recognize that class actions are favored, and this Court has instructed the lower courts that the rules are to be liberally.
I have a question just about what the class is. When I read the petition, I didn't see a definition of the class. When I read the district court's order, I didn't see a definition of the class. That strikes me as unusual. The Court of Appeals indicated that both sides kind of agreed on what the at least what the potential class would be. Is that correct?
Yes, Your Honor.
And that class consists of what?
So the class, as stipulated between the parties prior to the hearing, was that it included employees who had signed the Memorandum of Understanding, who had suffered a work injury, and who had come to Iowa for light duty. And that...
What does come to Iowa mean?
So, Annett Holdings employs over-the-road truck drivers who the Memorandum of Understanding is signed as a condition of employment. And in that document, it indicates that if there's an injury, Iowa workers' compensation law will apply. And as part of that, the employer will bring back the injured worker if they are released to modified duty or given temporary restrictions to their facility in Iowa to perform work.
So they're all outside the state of Iowa that have to come in Iowa? I mean, one of the questions I had was, well, if somebody in Altoona, are they in the class?
Your Honor, and I acknowledge that question. From my understanding of the rules, it's the plaintiff's job to define their class that they want to move forward with.
Are these the people who kind of stayed overnight at the Baymont? Is that, for want of another, is that the group? Is that what we're talking about? People who had to stay overnight in Des Moines,
basically, that came
in order
here
to do their light duty. Is that right?
Theoretically, yes. That is the group.
Did all of those people have therapy or medical treatment in Des Moines, or were some of them able to continue their therapy or medical treatment in the state of, or wherever they come from?
They did not all have medical treatment in the state of Iowa.
Right. And did any of them complain about their medical treatment in the state of Iowa, or seek to say file a petition for alternative medical care like Mr. Roland did?
None of the purported class members filed alternative medical care petitions. To the extent that there was any concerns or complaints about the medical care being provided, the employer worked with the injured worker and reached a resolution. The affidavits that were submitted by the employer to the court on the motion to decertify were all by drivers potentially falling within the class, indicating that they were provided a choice where to receive their medical care, and the affidavit indicates what choice they made.
Are we short-circuiting the Workers' Compensation Commission? I question whether many of these claims whether there's subject matter jurisdiction in district court. Don't we have to start with the agency?
Your Honor, I argued that on a motion to dismiss that was denied because, first and foremost, our position as 8520 gives the commissioner exclusive jurisdiction over the nature of the claims in this case, and this should not even be proceeding in district court. That motion was denied. We sought interlocutory appeal, which was denied. So
Did your subject matter jurisdiction motion, did it raise subject matter jurisdiction as to Mr. Roland or as to the absent class members? Because it strikes me that there's a different situation between Mr. Roland and the rest. Mr. Roland did go through the Workers' Compensation Commission process. The others haven't.
Correct, Your Honor, and it raised it on behalf of both. Mr. Roland, in this action, seeks to recover various workers' compensation benefits, which he claims he was deprived of because of how Annett Holdings handled his workers' compensation case. Our position was, if you felt you were deprived of those benefits, you should have raised that issue with the commissioner at the time your injury case was proceeding before the agency, and you didn't do so. And you can't now stand here on behalf of a purported class and suggest that the district court should determine what, if any, workers' compensation benefits these injured workers are owed because of Annett Holdings bringing them to Iowa for light duty without them first going through and before the agency.
Don't the individual questions predominate over any common issue? Aren't you have to go driver by driver, see where they live, how far, what care they needed? I mean, is there any gain to the system by trying to do this as a group?
That's why we're here today, Your Honor. I mean, realistically, if you look at how workers' compensation is set up, and it's a statutory creature, the whole issue is that is being alleged in this case is that that Annett Holdings, by bringing the injured workers back to Iowa, did not provide reasonable or convenient medical care to the workers. In order to determine whether or not there was, in fact, a deprivation of reasonable and convenient medical care, you have to look at each and every individual claimant, what medical care they needed, what they were offered, and that cannot be done on a class-wide basis. And to this point, Your Honor, and the reason why we argued both to the district court and the Court of Appeals that class certification wasn't appropriate is because although Roland argues or alleges in his petition that Annett Holdings used the memorandum to deprive these workers of statutory benefits, he has yet to identify how he can prove that on a class-wide basis, which is what he's required to do. The district court and the Court of Appeals just accepted his allegations in the petition at face value and said it can be established with generalized evidence on a class-wide basis. And our position is it cannot. And
isn't that what happened in the Microsoft case? Microsoft is the Combs case. You're familiar with it, I'm sure. It's kind of an interesting case. But among other things, the court held that there were common issues of law that included violation of antitrust statutes. Admittedly, I mean, there was no doubt that each individual that was harmed by the allegations would have individualized proof and so forth and so on. But as I read Combs, it basically stands for the proposition that a common issue of law or fact can be a violation of a statutory scheme. And they've alleged, at least here, a violation of 8520 based on your memorandum of understanding. So help me with Microsoft, and you understand my line of questioning,
Sure.
I think, yeah.
So the conduct of Microsoft in that case that was found to have violated a statute was a single pattern of conduct that, if proven that they did X, Y, Z, it provided a basis of liability for all class members. In this case, what is being alleged is that Annett Holdings uses this memorandum to deprive injured workers of statutory benefits. But it's not a specific act or set of actions that are alleged to have been wrongful and deprived. Annett Holdings acts independent of the previous case or the next case every single time someone gets injured.
And just to clarify for my benefit, the claim here isn't that the MOU on its face violates the statute, which arguably would be something common to all putative class members. It's the relocation for the assignment of light duty work that potentially interferes with medical care. That's the claim, right?
Correct, Your Honor. As I understand how the petition was pled and the allegations of wrongdoing in this case, it's not the memorandum of understanding itself that plaintiff claims is illegal, nor do we think there would be a basis, but in any event, it's Annett Holdings enforcement. Specifically, if you
Is
look...
Annett Holdings self-insured on this matter?
And
Workers for their work comp?
so Annett Holdings under the state of Iowa is an 8522 company, which is...
Administer their own claims?
correct, yes,
Whether they have secondary insurance is not important, but they do administer their own claims.
yes.
I'm having trouble. This doesn't seem like a suit for benefits. It seems like almost a bad faith claim on the way they administer their claims. And so they're really not asking for the benefits. They're asking for bad faith damages in the way they administer their claims. Do I have that right?
Your Honor, plaintiff's petition actually contains two different claims. One is a deprivation of rights under 8518. The second is bad faith, the allegation being that Annett Holdings continued to bring injured workers back to Iowa to perform light duty and receive medical care in Iowa after the Roland case had proceeded through appeal.
Why wouldn't bad faith have common questions of law and fact, the way they administer their claims, requiring people to come back, et cetera, et cetera?
Because, well, I mean, a bad faith claim considers whether the defendant knew or shouldn't have known their conduct was unreasonable, and that includes an objective standard as well as a subjective standard. And that can't be determined on a class-wide basis because what Annett Holdings actually did in each individual circumstances determines what was or was not reasonable. What medical care did the injured worker need? Did the injured worker want to come to Iowa? See, the assumption is that these injured workers don't want to come to Iowa and they're being punished by being brought back. But that's not necessarily the case. A lot of times, our injured workers don't have a permanent residence. They don't have anyone at home caring for them. We bring them back here, we provide them transportation, we put them up in a hotel that is a nice hotel that the public stays in. We provide them cleaning services. They have on-site, therapy offered to them, and we send them to some of the best medical facilities in Des Moines. It's not necessarily a negative thing, as the plaintiffs would like to suggest.
Have you got to the point where members may have opted out at this point, or you haven't got that far in the litigation?
Oh, so the affidavits that we've provided, Your Honor, that are in the record show that on occasion, show the occasions the drivers opted to have medical care in their home state.
I'm talking about opting out of the class.
Oh, no, we have not discussed that. But in deciding, whether or not there's a common set of facts that the plaintiff could, at trial, prove Annett Holdings deprived the class of statutory benefits or acted in bad faith, the plaintiff has failed to identify how that could happen or what evidence the plaintiff could bring forward that would establish that fact on a class-wide basis. And the entire purpose of the class action model is to streamline, a material central issue of a case of this nature. Each and every individual element, both what the plaintiff would have to prove for liability, what the plaintiff...
Wouldn't it be true that for a given worker, they wouldn't have a bad faith... Go ahead. They wouldn't have a bad faith claim unless initially they had actually been deprived of a benefit. So,
Absolutely, Your Honor.
So there'd have to be some showing And your argument in your subject matter jurisdiction motion is this would have to be a showing before the commissioner, not in a district court, that there had been some benefit, whether it was medical care or something else that they'd been deprived of, and then they could pursue the bad faith. Is that
exactly? Because 8527 subparagraph 4, which is where the obligation to provide medical care arises, indicates that the employer has an obligation to provide prompt, reasonable, convenient medical care to an employee. And if the employee is dissatisfied with the care being offered, the employee is to notify the employer in writing. And then it goes forward and says the employer and employee can then discuss amongst themselves and agree upon the care, the alternative care that the employee will receive. And so the statutory framework, and then if they can't agree, the employee can seek alternative medical care with the agency. So the statutory framework is set up so that the employer and the employee can, at the first instance, resolve any issues about the care that the employee is receiving or the employer is providing. And what this lawsuit suggests is that that doesn't exist, and the plaintiff can assert on behalf of all purported class members that the care offered by Annett Holdings was unreasonable. And that does not fit within our workers' compensation statute. I see that I'm out of time.
Thank you very much, Ms. Monthei. We'll now hear from Mr. Denning.
Good morning, and may it please the court, counsel. Iowa's class action rules are remedial in nature and are to be liberally construed to favor class actions. As recognized by this court in Freeman v. Grain Processing Corporation, the proponent's burden is light at the certification stage, and the district court is granted considerable leeway when deciding whether to certify the class. A district court's ruling granting or denying certification is reviewed for abuse of discretion, and an abuse of discretion is only found when the district court's grounds for certifying the class are clearly unreasonable.
I try and look at these class actions as, all right, I recognize most of these settle, but if it went to trial, and let's say you tried Mr. Roland's case, where would you be then? What would you prove? What would you have established with respect to anybody else in the class?
Excuse me. I think that is a somewhat difficult question to answer, just because, as the Court of Appeals noted in its decision earlier this year, we haven't been able to conduct any discovery in this case. We have an idea of what documents there may be or what evidence we could establish.
I mean, you know,
Before you get, I'm sorry. Yeah.
What we're looking for, and as Ms. Monthei mentioned, the petition is twofold in terms of different counts that are being made. It's deprivation of statutory rights and the bad faith claim. With respect to the deprivation of statutory rights, what we're seeking is not workers' compensation benefits. We acknowledge that the agency has exclusive jurisdiction to award such benefits as healing period or temporary total disability. What we would be looking for is damages regarding what's the value of the loss of those damages to the clients in terms of maybe non-economic damages, emotional distress. There's the potential for injunctive relief as well.
That sounds like a bad faith measure, right? Emotional.
I would
you
agree
wouldn't
with
be
that.
able to get that in the comp process, right?
Exactly. I definitely agree that there's some overlap between the deprivation of statutory rights in terms of damages versus the bad faith. And you're correct, the bad faith claim cannot be brought before the agency. That would be something that's probably...
Don't you agree that of these 40, that if you had somebody who never got medical care in Des Moines but was just relocated there for the light duty work, they really wouldn't be entitled to any relief under your theories?
I would respectfully disagree with that. I think it's important to note that the Jazz Freeman via Annett Holdings workers' compensation appeal decision, that was something that was provided to the district court for the class certification hearing, and that was discussed as evidenced by the transcript. And I want to read just a selected portion of that appeal decision. It's on page 3. This appeal decision was issued by Workers' Compensation Commissioner Joseph Cortez on January 31, 2018. And he notes on page 3, in finding defendant failed to offer claimant suitable light-duty work as required by Iowa Code Section 8533, paragraph 3. The Deputy Commissioner noted it has been held by this agency, by the Iowa District Court, and by the Iowa Court of Appeals that an MOU at issue in another case involving defendant, which is identical to the MOU at issue in this case, violates Iowa Code Section 8518. And then he goes on to further state that based on the fact that the MOU violates Iowa Code Section 8518, and also based on the fact defendant did not address why claimant was not offered light duty at one of defendant's terminals closer to claimant's home in Mississippi, I affirm the Deputy Commissioner's finding that claimant is entitled to receive healing period benefits from January 20, 2014 through March 4, 2014 because defendant failed to offer claimant suitable light duty work during the time period as required by Section 85.
But that sounds like a different issue. That sounds like the issue we had in the Neal case, right? That where the argument being that you couldn't even make them relocate to Des Moines, right?
I think that the reason why I wanted to read that passage for you is that I think it does go to your question, which is if they come to Des Moines for light duty work and they don't receive medical care, then where have they been deprived of the statutory rights? And this case outlines how this was an individual who, unlike Roland, did refuse to go to Des Moines for light duty work. The Deputy Commissioner didn't rule that he wasn't provided that he wasn't provided reasonable medical care. He still found a violation of 8533 because of that failure to offer suitable light duty work.
But in Neal, didn't we say that distance, et cetera, was a factor to be considered in the determination whether or not the work was suitable?
That was the holding in Neal.
Which, so on its face, we have not said at least, on its face, the MOU violates the workers' comp statute. Is that right?
There is not a case by this court that states that the particular MOU at issue in this case violates 8518. You are correct.
So you couldn't find there couldn't be liability without a case-by-case assessment of each worker's situation, distance, lifting, whatever the work restriction is, et cetera. Is that correct?
I would respectfully disagree with that because we already have two decisions from the agency stating that this MOU on its face does violate 8518.
But didn't the Court of Appeals use the words as applied? So as to Roland, who lived 900 miles away and had physical therapy going on down there, and he had an electric machine he needed, that on those facts this MOU violated. But I didn't read it as a blanket prohibition that this MOU for all drivers is per se illegal.
You're correct that the Court of Appeals decision used some of that qualifying language that as applied in this case. I still believe that both the Workers' Compensation Commissioner, Joseph Cortez, that his language does not have that qualifying distinction in there. He does not say as applied in this case to Jazz Freeman.
So setting aside a challenge to the MOU on its face, what would be the common proof that would establish liability against the defendant for this putative class?
Well, as Ms. Monthei had mentioned earlier, that what we've contemplated for the prospective class in this case are out-of-state truck drivers who were compelled to travel to Des Moines for light-duty work and medical care. And I think that the district court could take judicial notice.
I understand the class definition. I'm asking you, what is the common proof, the piece of evidence, that would show a violation of the statute for those putative class members?
that the MOU on its face violates Section 85.
Setting that aside.
But yeah, I mean, here's the thing. Like, if we compare this to Comis or to Freeman, you know, I mean, a couple of examples. All right, Comis, I bought a computer. I was overcharged. I'm a class member. The jury determines I'm entitled to $20 of damages because of that overcharge. That then helps determine exactly how much, you know, the rest of the class is determined who bought a computer. Same thing in Freeman. I lived near the grain plant. It was a nuisance. I'm entitled to $10 a day of damages. That helps determine how much the rest of the class members. In other words, the trialist of the class representative actually advances the ball as to the other class members. I want to understand how trying Roland's claim advances the ball as to the rest of the class. I mean, what you're telling me is you already have determinations of illegality. If you do, then what's the class action? There isn't any common proof because the only thing that's in common has already been established, right?
I would state that, let's just talk about the bad faith claim, for example. That, as we all know, that there's two components to a bad faith case. That Roland would need to establish that Annett Holdings had no reasonable basis for a denial or delay of workers' compensation benefits. And two, that Annett Holdings knew or had reason to know that it lacked that basis to deny
Don't you have to
benefits.
look at each person's medical history, medical condition, where they live, what's available, what's not available, in order to say it was bad faith? I mean, if there is a question, you know, of whether or not it should be given or not. I mean, it seems to me that your proof is going to depend on each individual situation.
So there's language cited by Deputy Erin Powles in the alternate medical care decision when she states that the general rule by the agency was there is medical care needs to be offered within a reasonable distance from the claimant's home. And it was established agency precedent that that distance is a radius within 50 miles from claimant's residence. Because our contemplated class members all reside outside of the state of Iowa, that's well beyond that 50-mile radius decided by Deputy Powles. So I don't think you have to look at exact specifics with respect to a claimant's or a class member's medical care situation or specifically even where they resided. I think just given it can be stipulated as fact that these members all reside outside the state of Iowa, they're all outside that 50-mile radius.
Can you cite a case from any jurisdiction where a class action was certified on a group of employees seeking workers' compensation benefits or bad faith?
Not that I was able to find, but just because the absence of such a case does not prevent the district court, or that does not equate to the district court in this matter abusing its discretion in certifying this as a class.
Generally, so Roland exhausted his administrative remedies. I mean, he worked all the way through and all the way to the appellate decision affirming his award. Have any of the other class members gone forward with proceedings before the agency, other than the one you mentioned?
Jazz Freeman. We're only aware of the truck drivers who my firm has represented for work comp cases, but again, without this discovery, we don't know the other class members where they're at in the process with their workers' compensation claim. For all we know, there are 40 who have gone through the agency and had arbitration decisions rendered. We don't know that information because it's so early in the process.
That kind of sounds like a fishing expedition to me.
I mean, we have a stipulation that there are 40 truck drivers. We're out-of-state truck drivers. They've signed this agreement, and they were compelled to travel to Iowa for light-duty work, and they received medical care while they were here.
Okay, so then back to the question that Justice McDonald asked. Based on that, how does your client alone, his trial, set the stage for everyone else?
I believe that Roland's trial, if that's how the district court wants to set this up in terms of a trial basis, they want Roland's trial to go first as a representative member. I think how...
Well, that's different. A representative member, that's like, that's different from a class action. A class action, it's not that his trial would go first. His trial would be the trial for the class. It's not that it would be a trial to then place a value for settlement purposes on the case. If you want to do that, you don't need a class action, right?
I believe that Roland's trial.
I apologize. I didn't mean to interrupt you. Now, listen to you.
No, I just want to make sure I'm hearing everyone's question and trying to answer.
I was jumping in.
I think, and again, how we anticipate the trial playing out is that if it can be established that, again, focus on the bad faith claim, that the district court prior to the trial has made a finding that on its face the MOU violates Section 8518. That can be established by the district court based upon the agency precedent. And going forward with Roland's trial, that basis that they knew or should have reason to know that they lacked a reasonable basis to deny benefits to Mr. Roland, I think that can be established because they were well aware that the agency had concluded that you cannot do this. The MOU violates Section 8518. You cannot compel these drivers to go to Iowa for light duty work or getting their medical care there.
How does that square with Neal? I know you keep citing this agency decision and the district court finding, but in Neal we said that this could be a consideration. Didn't we implicitly conclude that the MOU on its face does not violate the statute?
Well, the MOU wasn't at issue in Neal. What we had was it was the finding in Neal was that it's a factor to be considered in the offer of light duty work or whether or not it was suitable. So we take that holding from Neal, and Deputy Powell's and Joseph Cortez, with that precedent, still made a finding that this MOU violates 8518. So I think that's how you get around the Neal decision is that if they had made those decisions prior to Neal, then I think that Neal maybe has a greater impact on this case. But they still concluded the agency, who's been entrusted with exclusive right to issue benefits or award benefits to claimants workers, they determined that this MOU is not compatible with work comp laws in Iowa, and that you have issues with light duty work offers and with reasonable medical care without undue inconvenience when you have a document like the MOU being applied. But going back to your question, despite the agency's decision that this MOU violates 8518, they continued to enforce it. Roland, all throughout that appeal process, was still being compelled to travel to Iowa for light duty work, and he's getting his medical care, despite the agency concluding the MOU violated 8518. I see that I'm out of time. I apologize. May I just have...
Why don't you take 1 minute to sum up?
Okay, thank you. And then on judicial review, the district court affirms the agency's decision, and despite that, Annett Holdings continues to compel the drivers to come up here. And then Iowa Court of Appeals affirms the decision of the district court and the agency, and they still compel the drivers to come up here. So in summation, I believe that Annett Holdings has failed to establish that there was an abuse of discretion in certifying this matter as a class action, and this court should affirm the district court's rulings on May 30 and July 11th of 2018. Thank you.
Ms. Monthei, you have any rebuttal?
Yes, Your Honor. Your Honors, for the first time I hear counsel arguing that the potential trial strategy will now be that the memorandum of understanding is illegal on its face and void.
Can I ask a question? Have you provided in discovery yet the identity of these 40 people or any information about these 40 people?
No, Your Honor, and the reason why, this all came to head because of the nature of the discovery that was requested was very, it would have required 1,000 man-hours to put together what they were requesting.
Well, how about just the names of the 40 people and
Nothing.
details like that.
Because our position...
That doesn't sound like a whole lot of...
Effort to do that, right?
Right. But our position was, no matter what we give you in discovery, the fact of the matter is, because of the nature of the claims being brought in this case, they're not suitable to the class action model. There is,
Normally, there would be some discovery before, again, I'm thinking my experience, it's old at this point in time, but normally there would be some kind of discovery before there would be class certification proceedings, and there would be some sense of who the potential class members are, what their characteristics are. The situation we have here is, we're having to review a class certification decision without the benefit of much of a factual record, really based on representations by both sides, right?
Understanding, Your Honor. And in my brief, I cited multiple cases where, discovery was not allowed because it is, within the court's discretion in allowing class certification discovery because no matter what information would be obtained during discovery, the fact of the matter is the nature of the claims being asserted in the case are not conducive to the class action model. And so it doesn't make sense to require the parties or, the defendants in those cases to go through the time and expense of doing discovery when the end result is going to be the same. The claims being made are not conducive to being tried as a class action.
Wouldn't maybe that discovery help you? I mean, possibly you would have all these, some of the 40 people would say, I was delighted with my medical care in Des Moines. It was better than what I would have gotten at home. Some of them might say, I was able to get my therapy at home on the weekends when I went home every other weekend. And that might be relevant, right?
It's not going to help the plaintiff establish predominance and commonality in this case.
Well, what if the class was, I'm struggling with the definition of the class. We started out with that, and oftentimes these class actions, the issue is not so much compliance with the rules, but it's the scope of the class. So you do the discovery that in part affects the scope of the class. Maybe it would be reshaped upon discovery. Maybe it would be, people who complied with the MOU, notwithstanding objections. Or those that, the class might be defined as those that complied unwillingly, maybe. I don't know. But it's awful early in the game for us to know exactly how that class might be shaped up. But you're saying, well, it doesn't matter. I gather.
No matter how narrow you tailor the class, if you were to put certain conditions on how far away they lived, that they objected to medical care and received it here, the underlying claim in this case is that Annett Holdings deprived the injured workers of medical care under 8527.
And you say that's always fact-based.
It's the convenience is fact-based, and the care to be provided is fact-based, and that's established by case law. The reasonableness is a factual question. The convenience is a factual question. You have to also add into that the fact that the defendant, would have the opportunity to assert various defenses it may have with respect to every individual class member, and those defenses include settlements on a compromised basis where they agree to release the defendant of any and all claims.
Well, that's always true in a class action, though. Surely, in grain processing, if somebody had settled, he'd be bumped out of the class.
If there was an agreement on the particular medical care received, if they chose a specific medical care, I think one factor that's kind of overlooked in this case is, for Roland's case specifically, Annett Holdings authorized him to be surgically treated in his home state of Alabama, and he received follow-up care with his surgeon in Alabama. Annett Holdings made sure he got back home anytime he needed an appointment. He did physical therapy while he was down at his home state. The only medical care he received in Iowa was physical therapy sessions while he was here doing light duty. The tone of the Court of Appeals case suggests, we completely cut off all follow-up care and the like from down in Alabama, which is not accurate.
Ms. Monthei, your time's up. You want to take a minute to summarize, please?
Yes, Your Honor. Your Honor, class action, the class action model only works if a case on behalf of the purported class can be presented in a streamlined fashion by the class representative on some central issue, whether, in this case, it be factual or a legal basis. Given the nature of the claims and the individual circumstances and the fact that plaintiff's case rests almost exclusively on the way Annett Holdings enforced or carried out its light duty program, which would be individually tailored to every single individual injured worker, it's impossible, no matter how much discovery is done, for the plaintiff to come forward with a method of trying the claims made in this case on a class-wide basis. And for that reason, Your Honors, we request that the court reverse the district court and Court of Appeals finding that there was an abuse of discretion in certifying the class action in this case. Thank you.
Thank you very much. The case of Roland versus Annett Holdings is now deemed submitted. The court will stand in recess for 10 minutes. Will you please recess court?